Hello. Can you guys see me and hear me okay? I'm having tech issues again. It sucks. Hello. Hello, hello. Welcome back. I'm early today. This feels so weird to be early. Are you guys even used to be this early? Hello. We're going to be covering the Adam Montgomery hearing today that just happened this morning. It's not very long, so we're just going to get through it. I was appalled that he even had another hearing. I didn't know. And he's a monster, so I don't even know why he's still even I thought I thought for sure someone would have taken him out by now in prison. Um Adam Montgomery is a monster. If you're not familiar with the case, it's a rough one. Let me say hi. Hello, hello. I'm early. I feel like I need another coffee right now. I have quite a few lives planned for today. So definitely make sure you have your notifications on. We're going to be covering the Mark Sanchez case. We're going to be covering Kenzie case, the reading of the text messages. We're going to be doing the 𝐼𝐞𝐥𝐿 motion, and we're going to get into the deep dive of Ellen Greenberg. I'm going to start part one. I might switch them around. So just make sure you have your notifications on. We're gonna watch this hearing. This is your neck of the woods. Okay, so the Harmony Montgomery RIP, her remains have not been located. Her father is a monster. This case I have not ever covered on my channel, but I am very much well aware of it. I think Adam Montgomery is up there with Chris Watts. I think in terms of how brutal and how sad, I think, let me fix my light. I think that, yeah, he's up there. He's up there with the monsters. Um, Harmony Montgomery, to be honest, I don't even really know a lot of the details like in depth, but I guess I do kind of. I believe it was 2019, right? December 7th, 2019. Um, Basically, Adam beat her and unalived her, and he has yet to tell authorities where her remains are. She's the one who was put into the ceiling. If you ever heard about that case and how it was, am I getting them confused? We cover so many true crime cases that I'm like, wait, she's the one that was in the ceiling, right? He stuffed her into was it a bag or a suitcase? And then into the ceiling or vice versa. And her bodily fluids were leaking through the ceiling. Yeah, I know. I know, it's a rough one. I have not covered it. I do cover cases about missing children and unalived children, but, like, one, they're so sensitive to YouTube that it's like I know even talking about the Ellen Greenberg case today, I know because it's the S word, SUICIDE. YouTube does not like that word, and I feel like cases involving children as well, they're very, like, picky about what words we use, and they flag you. Oh, and I wanted to let you guys know since we're here talking gonna do this. Remember I covered the Kyron Lacey case? If you guys are not familiar with the Kyron Lacey case, he is one of he's a footballer who was basically framed, in my opinion, by LSP, Louisiana State Police. I do have a live on that, so definitely make sure you check it out if you're not familiar with it. But I got a notice about that one. And I didn't get like spanked by YouTube or anything. Like they were just basically like, it's very interesting because if you're not familiar with the Kyron Lacey case, he basically unalived himself due to the stress he was experiencing from being bullied and being basically convicted before he had a fair chance at a trial. So it involved, taking one's own life. And I got a notice from YouTube, and it was like, I'm gonna read a little bit to you guys because I was like, this is interesting. It says, "Hi there. We're reaching out because members of the YouTube community, including creators, viewers, or staff, have expressed concern for your safety or well-being after coming across your content with you posted with topics related to that S word or self-harm. And it said your video on 𝐤𝐸𝐿𝐵, and it says basically like goes into detail of like, what that word means and stuff. And it says, we have resources to help you. We care about you. You are not alone and help is available. Please take care, YouTube team. And I was like, oh, how kind. Thank you for checking up on my mental. Like that is so very nice, YouTube. I very greatly appreciate that. But they just send out like those little warnings. And so Harmony Montgomery, I think, is one of those cases where like it's rough. It's rough. Her father like beat her so bad in the car, and then her mom was there, her stepmom was there, right? Stepmom. What's her name? Kayla. Kayla Montgomery. She took a plea deal. I should probably do a deep dive on this just because it is one of those cases, but it's just rough. Anyways, I'm going off on a tangent here. Let's get back to what we were here to. What do we hear? The hearing. Supreme Court hearing. He basically wants a retrial for his conviction. I think it was something along the lines of 56 years to life. Am I right? Correct me if I'm wrong, please. I'm not a profesh in this one. And, I just don't know why the death penalty is available in some states or not. And why some of these people aren't getting it, like Brian Koberger, this man, so many that I think, I sometimes think like if they weren't worthy of the DP, then who is, Adam Montgomery is a monster. So anyways, let's get started. The hearing's not very long. I saw Widow. I saw Tara. Tara, thank you for becoming a member. Cree, hello, hello. I saw Danielle. I saw Augie. Hello, Augie. 269. Hey. Okay. Who killed who? Okay, let's get started. And they had other children, so they kept trying to bag between the kids. Oh my gosh, it's so much. Yes. He was innocent. Oh, 𝐤𝐸𝐿𝐵. I thought you were talking about Adam Montgomery. I was like, absolutely not. Poor baby, she got taken from her mom and given to them. That pisses me off. This is another case where CPS totally failed. Totally failed. He carried her remains to and from his job and placed her in the walk-in freezer. Yeah. What a sicko. Ugh. Anyways, before I go on another tangent, YouTube's been messing up with my stuff. Is that good? Is that size? Do you want me to be smaller? Do you want me to be bigger? I can try to finagle it. But as far as for a vertical stream, it doesn't really go much bigger. Pause. I kind of like this scroll. Melly, how do I message you privately? I have a business email, so you can definitely do that. I can drop it in a second. Yes, this case kept me up at night for real. Hey, Carrie, good to see you. Okay. Let's see. So yeah, you can email me then. Can you hear that? Let me know. Let me make sure my mic's set up right.
Yeah. This is case 2024-0304, State of New Hampshire versus Adam Montgomery.
Good morning. For the record, Justice Hans Marconi is disqualified
I feel like
in this
my
case.
headphone's not working.
And Attorney Phelan, I understand you reserved 2 minutes for rebuttal.
Yes, I have.
Please proceed.
Good morning. May it please the court, my name is Pamela Phelan, and I am here on behalf of Mr. Montgomery. Today, I'd like to talk about 3 issues. First, the court erred in joining the July 2019 assault charge with the homicide-related charges. Second, the court erred in admitting as intrinsic evidence of other assaults in the weeks prior to the homicide and of blocking.
I think the whole child, the DCS system, child protective, whatever they call it, I think it needs to be revamped all across the world. MA gave him court custody and they lived in NH with no follow-up. This case, yeah. Okay, so there's quite a few cases where, well, actually too many cases, where the parents get custody and they shouldn't. Some people that don't even deserve kids end up getting them and then do harm to children. And I don't get that. Those are the type of cases that really, really piss me off. But anyways, let's continue with this. Hey, Michelle, good to see you. It's been a while. I know I'm not usually live during the day. I like seeing the early people that I get to see. Hey, Patty. Okay, let's continue.
Communication between HM and her mother. And lastly, these errors were not harmless beyond reasonable doubt. I did raise another issue in my brief, and I'm happy to answer any questions about those, but I'm going to focus on these. The principal concern with these issues is that a defendant be tried on the merits of the charged act and not on propensity and character inferences that may be drawn from evidence of other acts and wrongs. On the first issue, the cases simply should not have been joined for trial. They were not logically and factually connected in a manner that does not solely rely or demonstrate the accused has a propensity to engage in criminal conduct.
What
Make a
bearing-
difference.
Go ahead.
Does it make a difference that the defendant had joined and the state's assented to motion for joinder in the first instance?
No, I
Let me know how you guys feel too about Kayla. Like, should she have gotten a plea deal? I mean, I for sure thought if Adam got the death penalty, he might tell where her remains are, but it's a really sick monster when he like still won't give up where she is. Like, she has not had a proper burial. Was this in 2019, if I'm correct? Correct me if I'm wrong. And the fact that now he's asking for a new trial is like beyond me. Like, my blood is like boiling. I'm sickened. I'm disgusted. But I guess that's the justice system where I guess he has a chance at making some type of argument, and that's why we're having this hearing. But does he deserve it? No.
don't. And the reason I don't is because my recollection is that the parties agreed to joinder early on in the pendency of the cases. And then as they neared trial, the defense moved to sever them for trial. The state did not contest that the defendant had a right to do that and to have the court look again
So if
at
it,
whether it should be
I guess
severed.
my question is, if it was in the best interest of justice at the moment the defendant agreed to join the cases, what changed?
What changed is I think through the as defense counsel said, through the development of the case in preparation for trial and additional information that was coming out about how the state was intending to present its case. And defense specifically referenced new discovery or new information in Zwicker letters that were being produced to the defense.
Are the Zwicker letters part of the record? Because I looked at the motion to sever, it references the Zwicker letters, but I didn't see them in the appendix.
No, they are not. But defense counsel talked about what was in them and state's counsel when they argued the issue about whether the charges should be severed for trial. And at that point, the defense was primarily concerned not only from what was coming from the Zwicker letter, but in how the defense was perceiving the state's theory of the case going into trial, that this was going to be a trial about demonstrating a pattern of abuse. And that was going to be the prejudice that was going to result to Mr. Montgomery by having the charges continue to be joined for trial.
So basically, the defense is challenging several key rulings from his original trial, claiming that there's legal errors, kind of just like she said, that allegedly prejudiced the case. And the prosecutors basically are going to argue that even if there were mistakes, that they were harmless beyond a reasonable doubt. So basically, they did not affect the outcome. So I say just don't waste any more tax money. Like, just put that man back where he belongs. I don't even would call that a man. That's like something, I don't know. He is a monster. I'm disgusted.
And that was the principal concern that the defense had and articulated to the trial court below.
Did the new information include any information provided by Kayla Montgomery?
I believe one of the Zwicker letters did include information from her. I can't remember exactly which witnesses were involved in those.
What's the significance of the two different states of mind between the July assault and the murder, the reckless murder?
I'm not sure what.
In terms of this analysis, does the state of mind of the two different criminal acts have any bearing on our analysis for joinder?
I don't think so. I haven't thought about it in that way. I've thought about it in going through the Brown factor analysis that this court has articulated, as well as the tests that the court uses to determine interests of justice. I think the concern when you join those two cases together in this case is that you have evidence of the July assault, which, as you note, did have a different mental state, a knowing mental state. But that evidence rested on several different witnesses who did not have credibility problems, whereas the homicide case rested on the testimony of 𝐤𝐤𝐥𝐥𝐲 Montgomery, and she had significant credibility problems.
So are you guys catching on to this? So basically, they're saying that the defense is saying that the trial court should not have tried the assault charge from July 2019 together with the unaliving charge in December. They argue that combining them basically allows basically the jury to infer, I guess, like wrongful character or bad acts. But like, and I don't even know. I thought you weren't allowed. I'm not a lawyer, so if I'm wrong on something, correct me. But I thought there was like a time frame. I'm not sure. Maybe I thought he wasn't allowed to appeal anything for some reason, or I guess do this, like request a new trial for some reason, but I might be wrong. Correct me if I'm wrong. Let me know.
So to the extent that evidence came in through the joinder of these two cases for trial about and through witnesses, third-party witnesses without credibility problems, the July assault was much stronger. And to the extent that the jury likely had significant doubts about what Kayla's version of events were for December 7, which is when the homicide is alleged to have happened, the jury could very likely have relied on the strength of that assault charge case in resolving doubts against Mr. Montgomery on the homicide charge.
Counsel?
Yes.
So is it fair to say that the Zwicker letter changed the defense's calculus with respect to the best interest of justice prong of the analysis, but that when there was a stipulation to join the two cases, that the defense had concluded that they were sufficiently related, that they ought to be joined? In other words, you're challenging relatedness, and my question is, doesn't the Zwicker letter only go to the issue of best interest of justice?
I don't think so. My recollection of the hearing on the motion to join or the motion to sever, which was also the final pretrial conference, I don't know how in-depth, I can't remember how in-depth counsel for the state and the defense went in to the original calculation or the original analysis of joinder. There wasn't a prior hearing on joinder, and so I don't know if we can be very clear or have a clear understanding that the defense at some point thought there was a relatedness, or the defense might have thought, just like the state, there may be some efficiencies in trying them together. But as the cases got towards the trial date, it was clear to the defenses, they made clear to the trial court that they were concerned about the effect of a potential pattern of abuse being used primarily to affect the jury's weighing of evidence on the homicide charges.
At the time that the state
With that evidence, regardless, like, we don't care if there's a pattern or not. What he did was horrific. So this is pissing me off. He's guilty as F. Yes, I agree, Patty. I agree.
initially agreed to joinder, was there a decision made or on the motion to eliminate to prohibit the intrinsic evidence that came in?
I don't know if, I think over a year earlier is when the cases had joined and started towards trial. I don't know at that point whether there was any written agreement or stipulation about evidence, or whether it was tied to the admissibility of other evidence in the case. And the other issue that I want to address this morning has to do with that ruling about some of the evidence that the court determined was intrinsic. I don't think that was there was any agreement that tied the intrinsic evidence issue to the joinder issue.
So the admission of but you would agree, I assume, that the admission of this intrinsic evidence, the assaults and abuse and neglect that occurred in the weeks before the murder, that affected the admission of this assault in July, that it made it compounded.
Correct. Yes. I mean, I think both issues are intertwined in the prejudice that resulted to Mr. Montgomery. And it's, even if we're looking at the joinder issue, I think to your point, the prejudice is not just to his trial on the homicide charge, it's also potentially to the trial on the assault charge, because as you point out, the intrinsic evidence came in as intrinsic to the homicide charges. And certainly it was there in the case for the jury to use in assessing both charges, the assault charge and the homicide charge.
Anybody who hits a child like that, I automatically assume they have I don't need to know about the bad acts or not. Like, that just says enough to me. You know what I mean? Like, he really did horrific things to Harmony. So basically, the defense is challenging the use of testimony by Kayla Montgomery, who pleaded guilty to perjury and cooperated with prosecutors. I'm reading like a little script of this. It says they argue she had credibility issues and that the trial allowed improper or insufficiently connected, quote unquote, bad acts, evidence of prior abuse. Why it matters. If the court properly admitted testimony with credibility problems, it could have had a chilling effect or excessive weight in the jury's verdict.
So I want to give you an opportunity to address harmless error, but why don't you proceed with your second argument?
Yes. So with respect to the intrinsic evidence issue, there were two pieces of evidence that I focused on in my brief, and I believe it was error. They were not intrinsic to the homicide-related charges, which is what the trial court found. It was the assaults in the weeks leading up to the homicide, and then the bar of communication. With respect to the assaults, the state, even on appeal, says that those assaults, prior assaults,
I was awkwardly going to wave, but I'm like, why am I going to wave? Hey, KB.
were necessary
Good to see you.
and essential to proving reckless intent on the homicide. That simply isn't the case. If you look at the state's evidence on the homicide charge, it's the evidence demonstrated, and the state argued that it demonstrated, that Mr. Montgomery acted recklessly by repeatedly punching HM until she was unconscious. You don't need additional evidence of prior assaults for which there is no allegation was connected to cause of death to prove that reckless mental state.
Reckless mental state. He's a psychopath. Yeah, Kayla helped and moved the conceal about it. I know. I never thought she should have got out. I'm kind of with, and this is my opinion only, I'm kind of like with Gypsy Rose. I'm like, lock their asses right back up. Like, why are people like that walking amongst society? I get it. There was rugs involved. She was afraid of him, but nah, to an extent. I'm kind of with ATS on this one. Kayla helped move and conceal the body. Yeah.
And all this
Doesn't it
evidence-
show the extreme indifference?
I think the charge itself shows extreme indifference. The evidence on the charged act, if you believe Kayla's testimony, that in and of itself is more than sufficient to establish recklessness. And I will also point out that this was not a mental state defense on the homicide charge. This was a defense that Mr. Montgomery was not the one who caused the death. It was Kayla Montgomery. And so intent on the homicide charge was not a matter in serious dispute. And I would also like to point out is if you're talking about other act evidence being relevant for intent, that's a 404B evidence that's subject to a 404B analysis. That's not an explanation for it being intrinsic to the charge.
Wasn't as the trial court noted, wasn't the jury entitled to some context about events leading up to December 7th?
The jury should be entitled to all of it. Yeah. Drakey says she helped dismember Harmony in the bathtub. Oh my gosh, my ears, my eyes. They could have gave her to her grandma. And that's the thing, Danielle. That's the thing, is they never do. You know, I don't understand. I don't understand. It's like with dumbass 𝐼𝐸𝐳. You know, another one, I'm like, you could have just gave the baby away. I don't know. Ugh. This one's frustrating. It's up there with Chris Watts, like I said.
I don't know why. I mean, context has to be tied to the actual the charged act. I don't know, and I guess this is a question for the state, but what about their evidence and proof on the homicide it has a hole or a gap in it that is impossible for a jury to understand and reasonably assess without having these prior assaults.
To Justice Donovan's point, your yellow light is on,
Yes.
and if you want to get to harmless error.
I do want to get to harmless error. I think that, as I mentioned before, the homicide-related charges rested exclusively on 𝐤𝐤𝐥𝐥𝐲 Montgomery's version of what happened on December 7th. She had significant credibility problems. She gave multiple inconsistent statements to the police before she eventually gave a statement that led to the basis of her trial testimony. She only gave that story after she had been arrested, jailed, and was facing additional jail time. She had theft and other kinds of convictions on her record that raised substantial questions about her credibility. She, according to the state, lied to the grand jury about what happened, and by the time she got to testify in this case, she was serving a prison sentence on perjury. She had significant credibility problems.
I agree with this. I agree 1000%. She had credibility issues and she shouldn't have gotten out. She should still be locked up.
The admission of all of this other evidence, either through the joinder of the July assault and the prior act evidence leading up to the assault, the homicide, all of that rested on other evidence. And it gave the jury a reason to, even if they likely had substantial doubt about what 𝐤𝐤𝐥𝐥𝐲 said happened on December 7, they could fill in that doubt by relying on the improper admission of the July assault evidence as well as the prior evidence leading up to the homicide.
Thank you, Attorney Phelan. You've reserved 2 minutes. Attorney 𝐈𝐸𝐬𝐧?
Okay, so fine. Kayla's not super credible still. That doesn't mean that Adam should be out. He's a monster. Drakey said Harmony had a very loving foster family that had spent considerable time with her, that loved her and would have taken her. I know. It makes me furious. Furious. She was also nodding off 𝐤𝐤𝐥 during her testimony. Yeah. She was high on the rugs. Shelbell says, but it's up to the jury to determine her credibility, not the court or the lawyers. That's actually true.
Good morning, Your Honors. May it please the court, Sam 𝐤𝐞𝐥𝐥𝐲 for the state of New Hampshire. Your Honors, the trial court committed no error when it denied the defendant's motion to sever, when it admitted intrinsic evidence, or when it admitted the body cam video. But even if it were to be assumed that the trial court did commit an error, any such error was harmless beyond a reasonable doubt given the nature of the errors alleged in this appeal and the overwhelming strength of the state's case, which consisted of eyewitness testimony, numerous witnesses who corroborated that eyewitness testimony, and a mountain of physical evidence, the summit of which held only one conclusion, and the jury reached it.
Do you agree with the defense that the murder conviction rested predominantly on Kayla Montgomery's testimony?
Not necessarily, Your Honor. Certainly her testimony played a large part. She was the eyewitness to what happened on December 7th, 2019. There was no specific evidence to corroborate exactly what happened in that car as far as eyewitness testimony. But to the extent that could not be corroborated and Kayla has credibility issues, so much of what Kayla testified to was corroborated by other testimony and physical evidence that she might not even have been aware of, that it would have become very easy for the jury to later credit her testimony about what happened in that car.
So if we excise the July assault, what evidence corroborates Kayla Montgomery's testimony?
Sure, Your Honor. So beginning with the blood.
Oh yeah, some of you said, where is the third judge? Don't know. There's supposed to be 4. I don't think they would be having court if they were doing something wrong. But when they mentioned the body cam video, there was an encounter between Montgomery and the Manchester police on December the 31st, 2021 that was shown. But the judge excluded the audio. And I think that's what they're referring to, that the defense is arguing the presentation of the video without the audio violated his right to basically, he got silenced and was deprived the jury of like the context because you couldn't hear it.
In the ceiling of the fit shelter, Kayla testified that the defendant hid Harmony's body in a diaper bag and placed her in the ceiling of the shelter at Families in Transition.
Put her body in a diaper bag and put her in the ceiling. Yo, hey, First Liberties, good to see you. Drakey says this case has so close to home for me. Ugh. Hey, Mallory. This monster, I can't believe the nerve of this flaming pile of shiz. I agree.
And the police went to investigate and cut out that part of the ceiling. It was visibly stained with bodily fluids. The DNA tested positive for Harmony Montgomery's DNA, a profile of which was built using her toothbrush. The defendant's fingerprints and palm prints were all over the vent of that ceiling. The only other fingerprints that were found were of the man who installed the ceiling.
But that only shows corroboration of the post-homicide actions.
Did you guys hear that? I kind of want to rewind it a little bit. I know it's brutal, but
corroborate exactly what happened in that car as far as eyewitness testimony. But to the extent that could not be corroborated and Kayla has credibility issues, so much of what Kayla testified to was corroborated by other testimony and physical evidence that she might not even have been aware of, that it would have become very easy for the jury to later credit her testimony about what happened in that car.
So if we excise the July assault, what evidence corroborates Kayla Montgomery's testimony?
Sure, Your Honor. So beginning with the blood in the ceiling of the fit shelter, Kayla testified that the defendant hid Harmony's body in a diaper bag and placed her in the ceiling of the shelter at Families in Transition. When the police went to investigate and cut out that part of the ceiling, it was visibly stained with bodily fluids. The DNA tested positive for Harmony Montgomery's DNA, a profile of which was built using her toothbrush. The defendant's fingerprints and palm prints were all over the vent of that ceiling. The only other fingerprints that were found were of the man who installed the ceiling.
But that only shows corroboration of the post-homicide actions of the defendant.
Sure, Your Honor. My ultimate point here is that all of these pieces of corroborating evidence of Kayla saying he hid her in the ceiling, he put her in the freezer at Portland Pie Company, he used a U-Haul to drive her and dispose of her body, he used lime to break her body down. If all of those things could be corroborated by...
What? Why did I forget that detail? Did I hear that right? He used lime to break the body down. That is terrifying. I forgot some details of this. So sick is right, Vanjie. Yes, Moonchild. Hello. What's the short version? You mean like why are they doing this? Because the state basically the body cam footage, Kayla is not credible and he deserves another trial because whatever. I don't even know. Like I don't even know why they're doing this, but allegedly his rights were violated.
Physical evidence to show that Kayla wasn't lying about those things, it becomes a lot easier to credit her testimony when she says, the look of an evil man in that car is why I didn't do more to stop him from raining blows on her face. That becomes a lot easier to buy once the rest of her testimony is credited, and very, very much of her testimony was. Again, through physical evidence and then through the testimony of other witnesses, such as Travis Beach, a friend of the defendant's. He testifies that, yeah, I helped procure the U-Haul truck. I couldn't get it myself, but my friend Brendan Harris could. Brendan Harris said the same thing, and then the U-Haul records show that Brendan Harris indeed did procure a U-Haul truck. Massachusetts tolls show that the defendant went over the Tobin Bridge in that U-Haul truck on March 4th, 2020 at 4:45 a.m., and he crossed back over going northbound at 5:25 a.m. The records showed that there was about 130 miles put on that U-Haul truck, and by the state's calculation, that would have lined up just about with the trip from the U-Haul back to the Econo Lodge down to about where the defendant allegedly disposed of Harmony's body and back up. So there was significant amounts of corroborating evidence. On top of that, outside of the Econo Lodge, Travis Beach says that he's outside with the defendant smoking a cigarette, and the defendant's pacing back and forth repeatedly saying, I effed up, I effed up, I effed up. And Travis asked him, what are you talking about? And he wouldn't clarify. That's the same night that he disposes of Harmony's body. So the evidence just built upon itself over and over and over again, and that's even before we get to consciousness of guilt evidence of the defendant himself. He tells somebody on a jail call that the efforts to find Harmony's body is just a waste of taxpayer money. One could draw an inference from that.
I forget this case. I mean, I don't forget it, but like all the little details, like what the helly? Under the jail, preferably. Yes, Patty, I'm with you. Where's Harmony, you effing coward? Couldn't even be present in court for his trial. He needs to say where she is. I'm sickened. Oh my gosh, I can't. He's such a monster. This case is horrifying. I know. I feel like I need to read the affidavit. I have it. We shall get into it. Oh, it's just too brutal. Anyways, I'll have to think about that one. Let me know if you guys want to do a deep dive on that. I just feel like so sad. She's a beautiful angel. She was so cute. Yeah, Nama Owens. That's why I was saying maybe we should do like a quick deep dive recap. He will be under it one day. It's one day too late, Danielle. One day too late.
I dumped that in a place you're not going to find it. Additionally, before he was arrested, but well after the murders, the defendant confides in somebody who calls themselves a close friend of his that he hated Harmony to his very core because Harmony reminded him of Crystal. That makes it really easy to start believing that this person took on an evil demeanor and rained punches on this 5-year-old girl's head until she was dead.
One of the predicates for the Superior Court's decision to allow the pre-December 7th
punches to the head until she was dead. Yeah.
Abuse and neglect of Harmony was that the court would give a robust instruction to the jury so that it did not take into account those prior acts in order to establish a propensity. Did the Superior Court give that robust instruction? I looked at the instruction and it did not seem to fit that description. Do you recall?
So what I recall, Your Honor, is in closing, in the final instructions to the jury, the court did instruct the jury, as is routine, that each indictment must be considered separately, and it was directly instructed to the jury that a finding on one indictment should not influence a finding on the other.
But there was no instruction on this particular evidence, the intrinsic evidence or the July 2019 assault.
I do not recall that, Your Honor.
I didn't see it.
I do not recall that from the record. Speaking of, just to pick up on that, there was some discussion of the intrinsic evidence causing the July 2019 assaults to bleed into the murder charge, creating that concern of propensity evidence.
Well, how do we reconcile the fact that the trial court limited the intrinsic evidence of abuse and neglect to a very specific time frame of 2 weeks prior to November 29th, and then the time frame between late November and December 7th, yet allowed in, obviously, by not severing the July assault? How do we reconcile that?
So I think they can be reconciled. First, I would note that they are certainly two different issues. One's a joinder issue and one's an intrinsic evidence issue. And I think the trial court took the exact right approach. The trial court was cognizant because the state moved for months of abuse and neglect evidence. Months takes us from November 29th. If months is plural, that's October, September at least. Then it could start getting into August. The trial court, my decision is somewhat here. These are joint charges.
Oh, whoa. Sorry, I'm thinking that's court TV issue.
September, August, God forbid, July, these cases might start to bleed together. So if the joinder order is to remain a sustainable exercise of discretion, the court has
Really?
before getting into why any of that was important. I think the easiest way to respond to that before getting into more substantive reasons is, as this court says time and time again in intrinsic evidence cases, events don't happen in a vacuum. This murder did not happen in a vacuum. The whole story is not told by simply recounting the events of December 7th, 2019. If that's all that is told, all you get is that in a vacuum. I'm not saying this would have been the defense or it could have.
Is that they're like, is that court TV?
2 years after.
Or is it me?
The story. The state has a right to present its case looking for harmony, both in the trial.
Let me go back a little bit.
It's really the beginning. The way that a father is supposed to treat a 5-year-old. Her life, he did not treat her the way that a father is supposed to treat a 5-year-old daughter. He treated her like an object of inconvenience, and that evidence showed that. Beyond that, as I kind of just wrapped up, it completed the story, and it was necessary to complete the story. The state has a right to present its case. The jury has a right to hear evidence that does complete the story, because, again, events don't happen in a vacuum.
If that's the case, then why was the video from 2 years later, why was that admissible?
Is that skipping on your guys' end too, or is it just mine? I feel like this court TV footage. Let me refresh it real quick. I want to make sure I can hear it. Hold on. I don't want it to skip while we're listening. I'll go back a little bit to where it kind of skipped. Sorry, guys. I think this is the only place I saw it this morning, so I should have watched a little bit of it. Don't come for me. I thought Court TV was on top of their game or something. I don't know. Whatever. Okay. Oh, I was like, why can't I see myself? Okay, now you can see me. Let's try that again. The audio skip. Yeah, I know. I don't think it's me. It's all
Yes, Your Honor.
Court TV.
Treated her
So I'll go to the part where it's not
the way that a father is supposed to treat a 5-year-old daughter. He treated her like an object of inconvenience, and that evidence showed that. Beyond that, as I kind of just wrapped up, it completed the story, and it was necessary to complete the story. The state has a right to present its case. The jury has a right to hear evidence that does complete the story, because again, events don't happen in a vacuum.
If that's the case, then why was the video from 2 years later, why was that admissible? What's the relevance of Manchester Police's encounter with Mr. Montgomery 2 years after the murder?
So that does continue to tell the entire
Does that continue to skip the whole time? Because I'm not going to be able to deal with that.
small probative value. I contend that it was more than minimal
I'm freaking out.
prejudice is that the jury is going to infer.
Can you guys hear that skipping? I wasn't even aware this is happening. I hope he doesn't get a new trial. I don't think he will. I don't think he will. He better not. I'm pulling it up on a different stream because I'm not going to take that and I want to finish watching it. I think Court TV is going to keep on skipping, so I'm going to pick a different one. And we'll play it from where we left off. I hope they're not all skipping. It can't be, right? Let me pull it up one sec. Okay. My headphones are acting up too. I don't know what the hell is going on. Okay, I found it. Okay, we're gonna start from here. Where he just said, the guy, the blows on her face. Okay, yay, yay. Don't hate me because the stream was sucking. Okay. Yay! And now StreamYard is acting up. Great. Yay! JK became a new member. Thank you, thank you, thank you. Thank you, thank you for supporting. That's a great way to support the channel. All right, I got it pulled up. Sorry, guys.
At Portland Pie Company, he used a U-Haul to drive her and dispose of her body. He used lime to break her body down. If all of those things could be corroborated by physical evidence to show that Kayla wasn't lying about those things, it becomes a lot easier to credit her testimony when she says, the look of an evil man in that car is why I didn't do more to stop him from raining blows on her face. That becomes a lot easier to buy once the rest of her testimony is credited, and very, very much of her testimony was. Again, through physical evidence and then through the testimony of other witnesses, such as Travis Beach, a friend of the defendant's. He testifies that, yeah, I helped procure the U-Haul truck. I couldn't get it myself, but my friend Brendan Harris could. Brendan Harris said the same thing, and then the U-Haul records show that Brendan Harris indeed did procure a U-Haul truck. Massachusetts tolls show that the defendant went over the Tobin Bridge in that U-Haul truck on March 4th, 2020 at 4:45 a.m., and he crossed back over going northbound at 5:25 a.m. The records showed that there was about 130 miles put on that U-Haul truck, and by the state's calculation, that would have lined up just about with the trip from the U-Haul back to the Econo Lodge down to about where the defendant allegedly disposed of Harmony's body and back up. So there was significant amounts of corroborating evidence. On top of that, outside of the Econo Lodge, Travis Beach says that he's outside with the defendant smoking a cigarette, and the defendant's pacing back and forth repeatedly saying, I effed up, I effed up, I effed up. And Travis asked him, what are you talking about? And he wouldn't clarify. That's the same night that he disposes of Harmony's body. So the evidence just built upon itself over and over and over again, and that's even before we get to consciousness of guilt evidence of the defendant himself. He tells somebody on a jail call that the efforts to find Harmony's body is just a waste of taxpayer money. One could draw an inference from that yeah, I dumped that in a place you're not going to find it.
A waste of taxpayers' money, and he's talking about his daughter, and he said they're never going to find the body. I bet you they couldn't find it because there was hardly anything left. He used lime to break the components of her body down. Oh my gosh, why is there people like this on earth? I can't comprehend.
Additionally, before he was arrested, but well after the murders, the defendant confides in somebody who calls himself a close friend of his that he hated Harmony to his very core because Harmony reminded him of Crystal. That makes it really easy to start believing that this person took on an evil demeanor and rained punches on this 5-year-old girl's head until she was dead.
One of the predicates for the Superior Court's decision to allow the pre-December 7th abuse and neglect of Harmony in was that the court would give a robust instruction to the jury so that it did not take into account those prior acts in order to establish a propensity. Did the Superior Court give that robust instruction? I looked at the instruction and it did not seem to fit that description. Do you recall?
So what I recall, Your Honor, is in the final instructions to the jury, the court did instruct the jury, as is routine, that each indictment must be considered separately, and it was directly instructed to the jury that a finding on one indictment should not influence a finding on the other.
But there was no instruction on this particular evidence, the intrinsic evidence or the July 2019 assault.
I do not recall that, Your Honor.
I didn't see it.
I do not recall that from the record. Speaking of, just to pick up on that, there was some discussion of the intrinsic evidence causing the July 2019 assaults to bleed into the murder charge, creating that concern of propensity evidence.
Well, how do we reconcile the fact that the trial court limited the intrinsic evidence of abuse and neglect to a very specific time frame of 2 weeks prior to November 29th, and then the time frame between late November and December 7th, yet allowed in, obviously, by not severing the July assault? How do we reconcile that?
So I think they can be reconciled. First, I would note that they are certainly two different issues. One's a joinder issue and one's an intrinsic evidence issue. And I think the trial court took the exact right approach. The trial court was cognizant because the state moved for months of abuse and neglect evidence. Months takes us from November 29th. If months is plural, that's October, September at least. Then it could start getting into August. The trial court recognized, wait a minute, my decision on joinder is somewhat implicated here. These are joined charges, and if the evidence of abuse and neglect starts to reach back into September, August, God forbid, July, these cases might start to bleed together. So if the joinder order is to remain sustainable, a sustainable exercise of discretion, the court had to separate those enough such that the jury would be able to evaluate them intelligently and separately, and the trial court did that by limiting it as it did.
Why does it matter? Hitting a child and what he did to her was, I mean, it's not that I'm condoning violence against women, because I'm not, but like, how is that going to change our mind? If he did that to Harmony, how is whether he put hands on Kayla back in 2019? Like, I don't understand. That's not going to change my mind. Do you see what I'm saying? Like, are you guys catching on to what I'm saying? I feel like I'm not making sense. I feel like what he did to Harmony is enough that that wouldn't play, I think, as just a regular human being, that wouldn't play like a factor, whether he laid hands on Kayla before or not. It's like, you already did it to a child, therefore if you could do it to a child, you could definitely do it to an adult. That's kind of what I mean, I guess.
Turning
Can you
now to-
respond to the defendant's argument that none of the evidence and that with respect to the 2 weeks prior to December 7th is material to the crime charged?
Yes, Your Honor. First, I note that Attorney Phelan mentioned she did not understand why any of that was important. I think the easiest way to respond to that before getting into the more substantive reasons is, as this court says time and time again in intrinsic evidence cases, events don't happen in a vacuum. This murder did not happen in a vacuum. The whole story is not told by simply recounting the events of December 7th, 2019. If that's all that is told, all you get is that in a vacuum. I'm not saying this would have been the defense or it could have flown, but you can start to maybe try to create the story that what happened there is actually a loving father, but he was under unimaginable circumstances, homeless, drug addiction, his children living in his car.
No, absolutely not. I'm not arguing with this man. I'm just saying, like, whether he was homeless on rugs or whatever does not mean you do that to Harmony. Like, there's just no excuse for what he did, period. I guess I'm just already made my decision about Adam Montgomery. So if you disagree, my apologies, but not really, because like it is what it is.
No steady employment. He was under so much stress and he just snapped in the most unimaginable way. That becomes a much harder argument to even start making if you don't let this story be told in a vacuum, if you get the context. The 3 weeks leading up to Harmony's death showed that the defendant did have extreme indifference to the value of her life. He did not treat her the way that a father is supposed to treat a 5-year-old daughter. He treated her like an object of inconvenience, and that evidence showed that. Beyond that, as I kind of just wrapped up, it completed the story, and it was necessary to complete the story. The state has a right to present its case. The jury has a right to hear evidence that does complete the story, because again, events don't happen in a vacuum.
If that's the case, then why was the video from 2 years later, why was that admissible? What's the relevance of Manchester Police's encounter with Mr. Montgomery 2 years after the murder?
So that does continue to tell the entire story of the case, Your Honor, because that is it's really the beginning of the story from the law enforcement perspective.
I'm sorry if you guys could hear the landscape guy outside my house. I'm sorry. Augie's like, he was drilling in the court, and it's actually my landscaper. I'm sorry, guys. I didn't know you guys could hear that. Oops. You guys could hear that? Oh my god, I'm so embarrassed. Truly, I am. Awkward. I'm like, I'm about to go yell out there, and I'm gonna take you guys with me in my slippers, and I'm gonna be like, "Sir, do you not understand that this is the second time I'm trying to get through this freaking hearing? First the court TV shitty audio, and now this man is out there blowing them leaves." I'm so sorry. No, I'm literally, you guys are literally about to see true crime happen. Like, I'm about to go out there and just be like, "Excuse me." Yeah, don't they understand we're watching this true crime? Can you guys still hear it? I don't want to play the feed while, okay, I think he's done. Oh no, he's not. I don't want to let him do his thing. Okay, if you guys don't mind, then we'll continue.
The investigation starts. That's the first interaction that law enforcement has with the defendant, and it is relevant that when this is reported to the police, what they know is that Harmony's missing, and they say, okay, let's find the defendant because he has custody of Harmony. And it's relevant for the jury to know when the police located the defendant looking for Harmony, where was he? Who was he with? Harmony wasn't there. That's certainly relevant. There is relevance to that. Now, I'm not going to say that the probative value is through the roof on that body cam video, but it was relevant. And the reason that it was properly admitted is because the risk of unfair prejudice did not substantially outweigh even small probative value. I contend that it was more than minimal probative value, but even if that's what it was, the risk of unfair prejudice did not substantially outweigh that. The prejudice that the defendant has set forth both in the trial court and in this court is really a tenuous risk of prejudice that is based on mere conjecture and speculation. This video had no audio. The defendant could not be heard. At defendant's brief, page 41, the defendant says the video shows the defendant seemingly answering questions. In that circumstance, and the defendant argues that the risk of prejudice is that the jury is going to infer somehow that he was not cooperative with police or that his right to remain silent was implicated. But the fact that there's no audio, he's shown answering questions, and that defendants carry into trial a presumption of innocence, there was no rational basis to speculate that the jury would take that video and just imply from it that the defendant was being not cooperative with police in that moment while they were just looking for harmony.
Was there any objection to the testimony about that encounter, separate and apart from the video?
I don't want to say definitively, Your Honor, but I don't believe that there was as I stand here, but my recollection of that is
There was a video where I said earlier, like the audio was not, you can't hear it in the video that was played. And I think still that doesn't matter. Like he's still a monster, audio or not. Like, why I don't understand why Adam Montgomery thinks he has a fair shot at being a free man.
not good enough to answer definitively. Looking quickly to the severance charges, the severance issue, the state notes that, as Justice McDonald pointed out, that the defendant initially moved to join these charges and assented to motion, and later had a change of heart, which he was entitled to do. The state notes that the case summary, which I don't know is part of the record, but the state could supplement if the court wished for it, seems to show an appearance of another defense counsel between the joinder and the motion to sever. And all of this is really to say that it seems odd that defense counsel at one point in time could have reached this conclusion reasonably and then changed their mind and perhaps reached a different reasonable conclusion, but then argues that
Yeah, First Liberties, you're right. You're right. It is a big problem. That's why that's why he's back here, because they're saying it was a violation of his rights. If the jury, he could get a new trial for that alone. Oh, let's hope he does not. I asked that about a lot of cases we watch. I don't know if it's delusion or stupidity, right? I know. Hey, Justice Jane, good to see you.
court clearly was unreasonable and untenable in reaching the same conclusion that they had reached earlier. Now, Justice McDonald also asked what changed. As the state argued in the trial court, as far as substantive information, nothing changed. What changed was that some of the stuff was now coming from Kayla. That, it's lost on me, as Justice Gould pointed out, how that could impact the relatedness factors. Perhaps it speaks somewhat to the interest of justice issues, but it does not speak to the relatedness factors. Secondly, the July 2019 assault evidence, it's a little bit difficult to game this out because it's sort of hypothetical, but if these charges were severed, it's certainly possible, if not likely, that the July 2019 evidence could have come into the murder trial under Rule 404B. Depending on what the defense and what the state of the facts were, the theories could have been modus operandi, lack of mistake, habit of the defendant in the way he disciplined the child, harmony, common plan or scheme. There's a number of theories that may have come in under anyway. The trial court may have been cognizant of that and thought that was another reason not to try the case twice. But even getting to the Brown factors themselves, the trial court's order was just manifestly reasonable. If you go through the 5 factors, the state conceded and the court found there was no temporal and spatial relationship, so that pebble goes on the defendant's scale. The commonality of the victims and the defendant can't be disputed here. That clearly goes on the state's scale. The similarity in the mode of operation. In July 2019, the defendant gets angry at Harmony and he punches her in the face. On December 7, 2019, he gets angry at Harmony and punches her again in the head. I see my red light is on, Your Honor, and so we would ask the courts to affirm the trial court's orders and rest on our papers. Thank you.
Thank you very much, Attorney Gagne. Attorney Phelan, you have 2 minutes.
Thank you. Time, I will cover 3 points. Regarding the corroborating evidence, Justice Gould, the state answered your question and talked about substantial, in their view, substantial corroborating evidence. As you pointed out, Justice Gould, the corroborating evidence is all about post-homicide conduct. And Mr. Montgomery at trial did not contest the charges and agreed to the charges of falsifying physical evidence as well as the abuse of corpse information. So the fact that there was corroborating evidence about those events doesn't mean that Kayla's version of what happened on December 7 was any more true. She had substantial reasons herself and credibility problems to not be telling the truth about what happened.
Wow.
Regarding intrinsic evidence, the state used a lot of words in answering some of your questions. The evidence was necessary to complete the story, to give context, to tell the whole story. This court has been very clear, whether it's talking about intrinsic evidence or 404B evidence, that those are usually passwords, or the court has to carefully construe whether those words are passwords for getting in propensity evidence for a propensity purpose. Evidence has to come in for context when it's necessary and essential to proving the charged act. The events leading up to December 7 and those prior weeks were not essential and necessary under the tests this court has applied for considering whether it's intrinsic evidence.
Why isn't it relevant to whether the defendant snapped on December 7th?
Well, that wasn't the defense at trial. And until and unless the defense opens the door to that kind of evidence under that theory, it's not admissible. And as we know, as the trial played out, the defense was not that this was a lack of intent. The defense was he didn't do it.
Thank you very much, counsel. Case
Wow. This hearing is insane. First Liberty says if the appeals court agrees this violates the Fifth Amendment, then any evidence related to this content will be omitted. The panel will decide if that proves the jury would be misled. Oh, and it ends
submitted.
here, I think.
Take a recess.
That was it? There's no way. Didn't they just say recess? But it's like ending now. Or did they end it completely? I missed that. So if the jury will be misled, what happens then? He gets a new trial, right? Let me pull up. Oh, let me pull up another. He's a waste of court of everyone's time. I know. I agree, Augie. Let me pull up to see if that's really how long it was. Because it seems like it was not very long. I'm going to look at court TVs. Oh, yeah, that was it. Sorry, I just want to make sure we don't miss anything. Yeah, that's it. Oh, I see. Pat I thought oh, so is there like a part 2 to this? No way. No, I think it's done completely. Court's in recess because they have other stuff to do later. The hearing is done. Yeah, I figured it was done. So then what? We're not gonna know until when? What has to happen now? I'm not a lawyer. So the hearing is what? Now they have to decide if he's worthy of it, worthy of the next step or what? Well, I say no. Well, it depends what the second jury says. If it's a hung jury, then the state can try again. Whenever the jury says not guilty, it's final. Let me see when the next date is. I'm looking it up right now. It says, oh, it doesn't say when his next trial is. Okay, the justices said the matter was under consideration, but offered no timeline for when they may deliver a ruling. I think that's in regards to this case. That's what I see on, like, the case updates. Wow. I can't believe Adam Montgomery's literally asking for a new trial. I mean, I'm not surprised. What a coward. I'm looking to see if I can see an exact date. Yeah, her body's never been found. Poor little Harmony. She's so adorable. I want to show a picture of her really quick. Oh, let me pull it up for you guys. It's so sad. Ew, get him off my screen. I want to look at Harmony. Ugh. I'm just being a brat. Sorry, guys. I'm gonna share my screen really quick. That poor baby. I know. Look at this picture of her. Oh, hold on a second. She's so cute. How cute she is. Aw. Can you guys see that? Yeah, you can. I don't know why I went small again. Dude, StreamYard is flipping out. Oh my god, I can't stand it. Sorry, guys. Look at how cute she is. Mm, that's really sad. Okay. She's adorable. I know. She is. I was gonna show you guys another one. R.I.P. Harmony. You didn't deserve that. She deserved better. That's so sad. Oh, dude, StreamYard is like freaking out on me. It's jumping screens. Anyways, well, I'm glad we got through that hearing. I'm still going to show you guys a picture of her. I can't wait to switch away from StreamYard. Okay, can you guys see that now? Oh, I didn't realize I wasn't sharing my screen. Oh, she's so cute. That's so sad. Well, whatever happens, her mother profited off her. I know. Respectful. I know. She's precious. What was her name arrested? Kayla? For many things, I think, but pretty much lying. Oh, thank you, Justice Jane. Such a beautiful little soul. I know. They will write and issue a decision whenever each side has an allotted time amount to make the argument and there's a red light. The U.S. Supreme Act has both a red and green light. So I will definitely post. I'll either go live about it or make a short when they have an answer or response. I knew little about this case until now. Yeah, the systemic failure of a system that can be so unnecessarily intrusive, cavalierly let this known addict walk off with her. I know. It happens to so many children too. And a lot are never spoken about. Yeah, Harmony was, oh yeah, she had a foster family that wanted her and that was going to take full custody of her. So sad. Definitely will stay updated on this and keep you guys updated. Make sure you guys hit the like button. RIP Little Harmony. We do have 4 other lives scheduled today, so definitely turn on your notifications. I'm going to go live right after this. So I will see you guys on the next one. They have he looks like, oh, really? A little brother, right? She had a little brother. Yeah. I think he's with foster family now, correct? Yeah. We should probably do a deep dive. It's been some time. Might be time to revisit it since this is going on. It's just really, really sad. And each should be ashamed. Yeah, they should. Okay. I'll see you guys shortly on the next one. Please make sure you hit that like button. Really helps support small channels. I appreciate you guys for being here, and I'll see you on the next one.